Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes. Just let me know when you take the podium if you wish to reserve time, and if so, how much. The arguments are being visually and audibly recorded to be posted online. Please keep your voices up and remain behind the podium. Please don't use the names of children in this matter. I know you both know better, but sometimes we slip. We have read your briefs, and we're ready to proceed when you are.
Good morning. May it please this honorable court, my esteemed colleague, Ms. Grasky, Ms. Sheets. It's a pleasure to be before you again on behalf of Ms. Rule, the mother in this matter. By way of history, this court has heard a portion of this case already.
Wish you reserve rebuttal time?
I would. I'd like to reserve 3 minutes, please. Thank you. This case was litigated one time before, in which case the trial court applied the wrong standard in reviewing whether or not the case could go forward on a change of custody. In the initial decision that this court made, reversing the trial court's decision, this court cited various support both in Ohio and from the Supreme Court of the United States that basically stood for the fact that the overriding principle in custody cases between a parent and a non-parent is that the natural parents have a fundamental liberty interest in the care, custody, and management of their children. This court went on to cite that it is well established that a parent's interest in the care, custody, and control of his or her child is perhaps the most fundamental liberty interest, perhaps the oldest of the fundamental liberty interests recognized. That the liberty protected by the Due Process Clause includes the right of parents to establish a home and bring up children and control the education of their own. I point that out because I do believe that is a very critical issue in this matter. We are dealing with a biological parent and non-biological legal custodians. They are not related in any way to the child involved in this matter, who is, as we sit here today, I believe 9 years old. Unfortunately, the initial litigation in this matter started when the child was 5 years old, and a lot has happened in the interim. The prior order that we're technically trying to modify was filed in August of 2014. Since that time, a lot has happened. I think the brief that we submitted, particularly the statement of facts, is clear. It's lengthy because I think there's a lot of factual issues that are involved in this matter when we're considering what's in the best interest of this minor child. But to surmise all of those facts, I can say that most of them are negative as it involves the legal custodians. And certainly with respect to my client, I would posit to you that most of the facts involved in her life are positive. I want to go first, if I could, to the manifest weight argument, which I generally don't make and sometimes find to be a futile argument. First thing I want to point out, though, is in a review of the trial court's judgment entry, continuing legal custody with the legal custodians in this matter, the trial court judge wholly ignores the recommendations of the 2 guardian ad litems appointed in this matter. One might ask, why were there 2? There were 2 because originally guardian ad litem Hawkins was appointed, did a thorough evaluation. Nobody questioned the work she did or the time she spent with the parties, the child, or the schools, or the other collateral sources. She issued a decision or a recommendation, that legal custody should go back to mom, my client, who sits in the courtroom today. That the parenting time should essentially be switched between what the legal custodians had and my client had, which my client at the time had basically every other weekend and a couple of evenings during the week. And that there would be some significant time for the legal custodians in the summer months because there had been a bond developed between the child and the legal custodians. Finding that the decision or her recommendation was in what she felt was in contravention of the wishes of the child, the court appointed Ms. Bevington as the second guardian ad litem. Ms. Bevington, who has done, by her estimate, her unrefuted estimate, between 75 and 80 cases, and testified to all of her training and her experience both as a lawyer and a guardian ad litem, did all the same things Ms. Hawkins did, interviewed all the parties, both privately and with the child present, talked to the collateral sources, and made a recommendation again that legal custody of this minor child should be returned to her mother. The judgment of the trial court from which we appeal makes no mention whatsoever of these recommendations and findings. The only reference I could find to the guardian ad litems in the decision is citation to some of their testimony. I don't think there's much refuted or disputed in the transcript of this matter. I want to move on to a couple other facts that I think are key to this court's decision. Again, I would refer you to the statement of facts that we presented. There's a lot that went on between, let's say, February 2015 to today. But while this case was pending the first time before this court, I thought some very important actions occurred that show well for my client and dispute or refute some of the allegations made by the legal custodians. While this case pended, and I believe this was the spring of 2017, the child involved herein, who at that time was 7 years old, had presented to the hospital, she actually had to go to the hospital, with severe dental decay. One might say, okay, we have a child who just happened to have cavities. That really wasn't the case with this child. This child had developed such terrible dental condition that my client was the first to notice it because there were black spots appearing on her teeth. It subsequently required medical intervention at the hospital because they needed to pull 3 of her teeth, do some pulpotomies, I think I'm pronouncing that correctly, because there was some decay, I believe, in the root structure of the teeth. When examined about that issue, now remember, we're in front of the Court of Appeals. Everybody should be on their best behavior when they're in the court system involved in a custody dispute. We all know that. The legal custodian, Lisa Parker, I mentioned her by name because there's 2, testified that, well, she's 7 years old and you just can't make kids brush their teeth at night and in the morning. This was pointed out to you because at that time, clearly the record shows that the legal custodians had the majority of time with the child, and in fact, at around that time, the legal custodians, even in the evenings during the week, had her at night and in the morning. So it was only Saturday mornings and Sunday mornings at this point in time that my client would have been responsible for dental care. I would think that's a lot for a child to go through. There's also some testimony from my client that she never received any information about a lot of these medical visits, that they frequently texted information, and there were no texts presented by the legal custodians that they apprised her of any of this condition or any of the dental or medical visits that occurred for this child.
None of that was on our family wizard either.
No, and in fact, I'm trying to remember, I think they did have Family Wizard, but I think they didn't use it. If they did have Family Wizard as an order, I think they basically ignored it because they were texters. Some of the texts were pages, voluminous, almost texting conversations.
I think the suggestion is, only going by briefs, that your client never signed up for Family Wizard.
That may be, but I think that may be because if you look at the texts that occurred in the summer, this is a fact-specific case, and I will say to you that if you look at the text that I believe were part of the record in the summer of 2015, you will find that they basically just talked via text. I don't think anybody, certainly there was no contempt filed on behalf of the legal custodians that they didn't like communicating that way. There was no question that there was, I think there was testimony by the legal custodians that there was a free flow of information by text. The other thing that occurred, contrary to the legal custodian's position that my client was not fit to receive custody back, in the summer of 2017, at the insistence or the suggestion of Ms. Parker, she voluntarily increased overnights with my client. Now that would seem to me to refute any contention on the part of the legal custodians that my client wasn't ready to get her own child back. One would think that if you're the one contesting that she's not fit, you're not going to freely offer additional time to such a dangerous person. I say that facetiously, and I probably shouldn't, because there is no allegation that my client is a dangerous person. So I think that what occurred right on the crux of the new trial, this court subsequently reversed the decision, I believe, in September of that year, and then we went back for trial in 18. And then went through the whole process, and it was delayed because we had the 2 GALs. Sort of seems to indicate that my client was more than ready to receive the child back. I should also note, just to surmise some of the big points that occurred since the prior custody entry, in 2015, part of the reason that this was before the trial court the first time was because the legal custodians had led my client to believe that entering kindergarten, she would go to Cuyahoga Falls, essentially 1 block from her home. They both attended orientation at Cuyahoga Falls School District in August, I believe it's August 13th of 2015. At that point, they had not told my client that their house had been foreclosed on, that they were losing their home in Cuyahoga Falls and trying to find another place to live. There was an indication that they were actually going to try to move to Florida until my client put a stop to that. Then on the eve of school starting, there's some dispute as to whether or not it was a day or two before or the day of or after school started. My client found out they had moved to Deerfield, outside of Summit County. They then told her for the first time that the child was going to Deerfield schools, or the Southeast School District, excuse me. And my client had no choice but to seek this court's intervention. They also refused to follow the prior court order by filing a notice of intent to relocate. Whether you're at domestic relations court or juvenile court, you know that's the process. They didn't try to schedule a hearing as was required by their order. And it had been determined that in the interim, despite the prohibition in the prior custody order, they had encouraged the child to call them mom and dad, which was something that was not permitted. The trial court actually found them in contempt and issued some orders relative to that. So you have the foreclosure, you have the chicanery with my client's own child's school, her first time entering school, and then the court finds them in contempt and these other issues that have arisen. I don't know if there's any questions yet from the court, but I'm...
Is it your opinion that the court placed too much emphasis on what the child wanted?
Yeah, I think that's probably, Your Honor, the only justification. I don't mind not having 3 minutes, the full 3 minutes. I don't see any other rationale because this court's decision in the first go-around was clear. There is no equal standing. If you go through it, one of the things I was going to discuss, I don't have time, and I'll trust you. We'll obviously read the brief in the transcript. It's almost as if they go through the statement or the factors to consider in 310904 and say, well, they're equal, so we're not going to change anything. They're equal. The child doesn't want to change custody. They're equal. And I want to say something to that point that I think is critical. I actually did not believe Ms. Hawkins needed replaced as the guardian ad litem. Her position was there was a difference with the child because the child felt legal custody should stay with the Parkers. What she told both GALs is that she wanted more time with mom. Now, the GALs both recommended more time with mom because they basically said legal custody to mom and flip the schedule. If the child wants more time with mom, I'm not sure we should be putting who gets legal custody in the hands of a 7-year-old. I really didn't think that her position differed from what the child wanted, because I don't think it's the child's position in any way, shape, or form, and certainly not at the age of 7, to say, I want legal custody to stay with the Parkers, but I want to spend more time with my mom. That's uncontroverted that occurred. And as I pointed out earlier, in summer of 2017, the legal custodians voluntarily and at their insistence did it. My client willingly accepted. She's never missed her time with her child. She's the only one that's enrolled her since kindergarten in an extracurricular activity for which she's paid entirely. She attends everything. There's nothing that you can say about my client, I think, that would hamper this child being returned to her. And I would just say, if not implore, if not now, when? When, under these facts, is it going to get better for my client? She's married. She's got a steady job. She has a steady home, unlike the legal custodians. Her child loves her. There's no question about that. Her child wants to spend more time with her. There's no question about that. If she doesn't get her child back now, when is she going to get her? This isn't an adoption. She's never been accused of abuse. Even at the trial, there's been no accusation of abuse or drug dependence or abuse of alcohol. I can't understand why this trial court made the decision it did. Certainly against the wishes or recommendations of two guardians ad litem. I'll hope you'll give me a minute if I need it. If there's any other questions, I'll,
4 seconds for you.
okay, I'll do what I can. Thank you.
May it please support counsel. My name is Leslie Brasky. I'm here on behalf of the legal custodians in this matter. And I would ask that in reviewing this matter, the court use the standard established for reviewing this kind of case, which is an abuse of discretion. And if one reviews the facts in this case, perhaps the thesis statement might be that the magistrate noted that when mother was asked about why custody returning to her would be in the best interest of the child, she responded that it was her right to raise her child. And the magistrate noted she didn't have any statement as to how it would benefit the child to live with her. Both the magistrate and the trial court found that the child was doing well with the legal custodian. That's why she wanted to remain there. She was adjusted to her family there. She was adjusted to her extended family. And notably, the legal custodians had ensured that she remained in contact, in frequent contact, in voluntary increases of contact with mother. They were looking after her rights, the child's rights, to have people who love her in her life. The child had resided with the legal custodian since she was just over 2 years old. Prior to that, she had resided with the Ms. Atkinson for a good chunk of time, and when she was no longer able to provide the stable home for the child, the partners said, well, we can help. If you look at this matter, you can look at it through the prism of mom's rights, mom's needs, or you can look at it through the child's needs. This child has had one real home that she remembers, and that's the legal custodian's home. They have not deprived the child of access to her mother. Mother has engaged her in activities, which was an agreement between the legal custodian and the mother. That was her contribution to the child. She got her involved in activities and was responsible for that. That was a good cooperation rather than saying, oh, we need a child support order. The child, as a result, could maintain a close relationship to her aunt, who is the same age as she is. She could maintain a close relationship to her maternal grandmother and step-grandfather and I guess it would be uncle, through that relationship. These people have worked well together until the litigation started. There were some issues that were raised as to the legal custodian's mental health. However, both the magistrate and the trial court found that there was a diagnosis and there was appropriate treatment and that it was complied with. That was what is in the record. However, mother, when she was pregnant with a second child, repeatedly struck herself in the stomach, and I'm not asserting causation here, and ultimately miscarried that child. She did not seek mental health treatment after that. That was noted by the magistrate. The child had resided with the legal custodians for roughly 6 out of her 8 years at the time of the decision. We've talked about the general people adjustment. She's adjusted to the actual setting in which she's been living. She's adjusted to the school in which she's been attending. She's adjusted to the community surrounding the legal custodian's home and her school.
Counsel, let me ask you something about that. In terms of those adjustments, and I'm just going to specifically talk about school now, I can't imagine any child would say, yeah, I'm fine, take me out of school and put me somewhere else. That's very difficult. But in light of how this case has, gone back and been retried again, the fact that she's now adjusted in a school that's so far away from mom, isn't that school or having to change schools perhaps wouldn't even have been an issue for the trial had they not moved to where they did.
I can understand the question. And I can't say what the trial court should have done when the child started kindergarten and they actually moved. I don't know what they would have done. The problem is that that's not what happened. So now we are dealing with the situation of, it's not what's good for mom, it's not what's good for the legal custodians rewarding them. It's what's good for this child. That has been her home, and that has been her school, and that's been her community, and that's been her friends. The legal custodians had lived there for about 3 years at the time of trial. It's now well into 4 years now. You can rent a home without being unstable. Mom, but on the other hand, lives with her maternal grandmother. If something happens in that relationship, she could be out of that. I'm not alleging that. I'm just saying that's not really a housing stability issue. And it may be unfortunate that there's a reward there, but we're really supposed to be looking at this through the child's eyes. What's best for her? Where has been home to her? And particularly in light of the legal custodian's consistent facilitation of contact with mother and voluntary increases, I think that indicates their willingness to work with mom in this situation.
Counsel, as it relates to a situation that we have here in this case, does the child have some interest, be it tangible or intangible, in having the natural parent be also the legal custodian? Is there some, I don't want to use the word right, but some interest in that, some value in terms of the best interest test?
I can't imagine that any of the factors of 310904 would not inure to the best interest of a child. So no, I can't deny that there is a potential for an interest, for lack of a better term, in being in the custody of her mother. I'm not going to deny that. However, the magistrate who heard the evidence, who saw the witnesses, who listened to the testimony, who looked at the documents, determined that this child's best interests were served by remaining where she had lived with the legal custodian. The trial court reviewed the transcript, reviewed the evidence, reviewed the magistrate's decision, reviewed the guardian's report because he noted in the decision, and made the decision that magistrate had correctly determined the best interests of this child and that she should remain in the custody of the legal custodians.
This wasn't a dependency, neglect, or abuse case, so there wasn't any finding that mom was a deficient parent, anyway, it was an agreement. Was there any intention at the time the agreement was entered into, when the child was 2, that it was intended to be permanent?
I don't believe it was intended to be permanent.
So there was always hanging out there the option at some point this child may go back to mom.
Well, you say always, but as of 2014, when it was agreed that they would have legal custody rather than a piece of paper that says she'll live with you, I believe that did change in 2014.
Once legal custody was
Yes.
granted. Okay.
I think that the dental caries issue is really was not well litigated before the trial court. However, this child didn't develop the kind of caries that ultimately resulted in surgery in the year and a half, I believe at that point, it might have been 2 years at that point, I don't have the transcript in front of me, when the severity of her dental issues came to light. That kind of, counsel said it correctly, I will botch it, Sepulveda issue comes from early childhood dental issues. It doesn't happen because you don't brush your teeth often enough.
Is there some expert testimony in the record regarding that?
None whatsoever. Either way. The parties testified regarding their texting to one another. Everyone acknowledged that they would have fairly long conversations. I believe family wizard would help everyone in this case. However, they did not use it. And the legal custodians testified that they sent texts to mom saying it was just a regular appointment. And she didn't attend it. I don't know that she's required to attend it. Certainly not critical of her that she didn't attend every doctor visit, every dental visit. But she was made aware of them, and she was made aware of the surgical issues so that she could come, and she did come. Except for the involvement of the word legal custody, these parties have gotten along remarkably well in the best interest of this little girl. And the trial court, who was there and listened to the people and heard their testimony and reviewed the evidence, determined that it was in the child's best interest to remain with the legal custodians. We would ask this court to affirm the lower. Thank you.
Thank you.
Okay, I thought I had 42 seconds rather than 34, but I will go quickly. With respect to the intent to return the child to mom, the court can only look to the transcript of the trial and see that I believe it was the legal custodian's position mom wasn't ready yet. It wasn't that she wasn't to go back. Next, with respect to the dental caries, read the transcript. Legal custodian testified that she had them, it was tooth rot, and she testified herself that she could not make this child brush her teeth every single night. With respect to everything else, I just would ask this court to please rely on the transcript and look at our statement of facts, because I think they're pretty clear.
Okay, you got 2 seconds, can I answer one question? Just real quick. Did you guys attempt mediation at all?
Yes,
You did?
yes.
So it was successful, okay.
Thank you.
All right, thank you both sides for your presentations. Court will take the matter under advisement, issue a written decision, and